So you will see more and more security token offerings. Even if you have a lot of people saying, yeah, but what's the added value there? You can do an IPO. Yes, but you don't do an IPO in every case. That's really inefficient.
Hello, everybody. Welcome back to Value Tokenized with Masha and Zenia. Today, we're speaking with Thomas Naegele, Liechtenstein-based attorney who helped the local government draft the blockchain law, which was just approved during the first hearing. And what is also very interesting is that Thomas is experienced software developer. So Thomas kind of bridges two sides, law and code. And today he will share his thoughts on this, on the development of the industry and the local regulation in European Union. Hi, Thomas. Thank you so much for being with us at Value Tokenized. You are a Liechtenstein-based attorney, and you helped the local government draft the blockchain law, which was just recently approved in the first hearing, which is very impressive. Can you tell us how did this process go, and how did you contribute to this law?
Thank you very much. First of all, thank you for having me. And yes, I mean, that process started back in 2016, where actually our government decided to first raise, I think, the right question: is regulation needed in that area? So we started a work group, and I was part of that work group. And we analyzed, and I think that's the right approach. We started with understanding the tech behind it. So we really went deep there and analyzed transactions and the different blockchains, and in that work group we built up a lot of knowledge. This actually then gave us the ability to decide, or like to propose to the government and say out of the work group, yeah, we think it is necessary to regulate, but it's not necessary to have the same approach as we always have. I think, and that's the answer of the recently released version of the Blockchain Act, where you have, yes, you have regulation, but it regulates where new regulation was needed. So, for example, if the technology provides solutions which works, and you don't need any special additional regulation, then don't regulate it. But for example, if you have parts of the tech, like for example the civil law part, when you transfer a token from A to B, then the tech works, that's fine, there's no problem from that end. But the problem is that your legal framework, your underlying legal framework, has just to accept or to agree on that if you transfer a token from A to B based on the rules of the tech, that then B then is the new legal owner, if you want to call it that way, owner of the token. And that's actually, in most cases, that's not clear. But the problem is, if you don't have legal certainty at that end, I mean, all of the transactions, nobody can trust them anymore. And this hinders innovation. I mean, this hinders adoption, and that there are a lot of areas where legal certainty was needed. So we started with that, and then, I mean, our government said that's a good suggestion, and then we started to draft legislation, actually, and proposed the first draft. And this was there was like a public consultation phase for several months, and we got a lot of feedback internationally from other jurisdictions, from other advisors, from the industry, a lot of feedback. Back then we had about roughly 160 pages. There was like the act was roughly 50, 40, something like that, and then a lot of comments for 160. And now we ended up being 300 something, 370, 80 roughly pages. And yes, last week the parliament passed it in the first hearing, and we were very glad and happy that our parliament sure analyzed the risks as well, but thought that the overall opportunities are convincing.
Yeah, this is very impressive. Congratulations on that. And I have a question about adoption. You mentioned that there are some problems that can stop adoption of technology. And do you think that regulatory clarity can actually accelerate adoption, and what else is needed to achieve it?
I think for the consumer, regulation is something they don't care if they decide if they want to use tech. I think you have to differentiate between consumers and the industry, because the consumers, I mean, what they care about is it very easy to use? Is the user experience great? Is it a very nice design? So, for example, if we have, and that's what we see now, we have a lot of solutions based on blockchain and DLT tech, which even don't mention that they use blockchain, but they just provide a better solution. It's faster, more efficient, and very easy and nice to use. And I think that's needed on the one side. And where regulation comes into place is for all of the financial market players, like for the financial intermediaries, because what they need is legal certainty. They have to follow sure, I mean, consumers as well, but like the financial intermediaries, they're highly regulated. So it's very hard for them to analyze and assess the risks involved if they use a new technology and they don't know if it is from a legal point of view allowed to use this tech. What do they have to do? What are the requirements? I mean, one question which a lot of financial intermediaries ask us is, how do we like really implement a sufficient KYC and AML policy? And this is actually, I mean, that's not an easy thing to do. And it doesn't end with like blockchain analysis and transaction analysis. It's really, it is possible, but it's just a matter of time until the knowledge is there. And their regulation helps a lot, because if you can say a financial intermediary, you see there's this blockchain act or legislation which gives you actually all of the requirements you have to have, all of the like rules you have to follow. They have a clear path what they have to do. That's one thing. And on the other hand, I mean, that's even from a liability point of view crucial, because this gives legal certainty also for liabilities, because in our system at least, if you follow all the rules, in most cases you're not I mean, then you're not liable if something goes wrong.
And so, still, like Switzerland, Liechtenstein, these jurisdictions, they're paying a lot of attention and creating a frictionless environment for tokenized securities. But do you see interest from the final target audience, from businesses? Are they looking into tokenizing their equity or other assets?
Yes, I mean it's at I mean I think we did the first ever security token offering within the European Union framework. That was last year in August, which was approved by a financial market authority, by our financial market authority, and then passported to the European Union. And like I think now we had, there was actually a German, originally Germany-based company, which actually used Liechtenstein as their new jurisdiction. But we saw others, and recently we saw projects out of Liechtenstein, so well-established companies which like they developed software solutions for the supply chain industry, and then they saw, okay, there's a big opportunity, and anyway we have a demand for using blockchain tech in our software solutions, and then they said, yeah, we have to increase capital, and which solution should we use? And then they said, let's do an STO, and that's amazing. And actually, both jurisdictions, Switzerland and Liechtenstein, they have solutions to tokenize equity. And actually, Liechtenstein is there in a very good position, because we have like dematerialized bearer shares, for example. We have them since the beginning of our corporate law. It's really, I mean, our corporate laws are very flexible anyway, but this helps us a lot now with the security token offerings, because for us, really, you can have like a token which represents your voting rights, your dividend claims, everything, and there's no that's really as frictionless as it could be.
And speaking about security token offerings, in your opinion, what's the main incentive of using STOs as a fundraising method? So maybe it provides like the more like smooth experience, or it costs less. What are the main reasons to do an STO?
When we started with the first one, it was not that easy to be very honest. And it took us, I think it took us 5 months or something to get because there, this was an emission where we wrote the prospectus based on the prospectus directive, and then we got it approved by the Financial Market Authority. And yes, that was quite a process for the first one. But now that I mean, it's getting easier and easier. It's like if you do that a lot of times, I mean, then it's just like the overall cost. They came down like quite a lot lately. And that's one thing if you want to have a prospectus, or if you need a prospectus because the prospectus directive is applicable. Um, but my example is, I mean, if you go a little bit further, like let's say midterm or long term, I think that might be maybe a solution for a local bakery if they want to have a new oven. And I mean, now in Europe, what they would do is go to their bank and ask for a loan. But the thing is, I mean, that's actually that's very costly on the one side, and the other thing is, the problem is that the banks, it's more and more harder for them to grant these loans. So because of regulation. So what he could do, and I think that will happen, is he could just like use a small QR code next to his store, or like that directly in his store. When the customer pays, you know what, we want to have a new oven. It costs us, let's say, 60,000 Swiss franc or US dollar, and because we have to increase our capital, and you could become a shareholder of our company, and in addition to that, for every piece of bread you buy, you get, I don't know, 5 or 10% discount, because then you are a shareholder. The only thing what you have to do is scan that QR code, download an app, and then buy shares. And he could buy for 50 Swiss franc shares, or for 100 Swiss franc shares, because that's what we see now. You have all of these like one-stop shop security token offering platforms where it's really very easy to do that. And as soon as we have like the legal framework which allows you to tokenize shares, this could be like reality quite soon, I think. And because then for such a small emission, for 60,000 Swiss franc, you don't need, I mean, a lot of investor protection information and stuff, and a lot of, I mean, you don't need a prospectus, you don't have to file it to the Financial Market Authority. So if this is an easy and very easy to use, smooth process, and it's that for sure will be very cost effective, I think we could see that in the future.
And I will ask one question that's more philosophical, maybe, so to say. So you're not only an attorney, but also an experienced software developer. So it's kind of this industry, I think it's the intersection of both of these worlds. And what do you think about this saying, that a lot of people use it right now, especially in the tokenized securities, that code is law? What's your position on this? Is it?
I have to share an experience. I think it was a year ago or something. I held a presentation in front of roughly 100 lawyers, and the title was Smart Contracts. And I mean, I pushed the button, and there was on like the title of the presentation was on stage, and they argued with me, like lawyers argued with me about 10 minutes, that smart contracts are neither smart nor contracts, and I shouldn't call it that way. And I said, get used to it. that's just the way. I mean, we use that term, and if you think it's a contract or not, that's on a different piece of paper. Code is law. For me, I mean, I have two hearts, I have two heads, as you already said. I mean, being a coder, what you do is you set the rules, and within that system, it's auto-executing. That's true. I mean, code is law. Whatever you program, the system will do. But as a lawyer, law is passed by parliament and then enacted, and if that's a different thing. So if you write a code, it's not past parliament. So you will write your own law. And I don't think that. Sure, I can decide if I want to use code. So I can actually opt in. I can decide, okay, if I want to use that rule set, and if I use it, sure. I mean, then I have to accept that whatever is coded will happen. And I think both is true. Code is law on the one side is true. On the other side, as a lawyer, no, it's not a law in the meaning of being a law like passed by parliament. And I don't think that it would be good to have. I think this is combinable anyway, because this will happen. I think in depending on how fast it is. But for example, you have mandatory laws as well, where you cannot like define your own rule set, at least in our legal system, and I think that's for good reason. So we cannot get rid of all of the mandatory laws, because these are here for protecting the people. And I mean, not a lot of people understand code, and not a lot of people are able to analyze the code before they are using it. And I don't want to do that. I don't want to analyze every piece of software before I use it. And therefore, mandatory rules are really necessary. And so if I sign a contract with a bank, for example, today, I mean, nobody reads the whatever 50 pages they give you with every term and every clause. And there are mandatory laws protecting consumers, that if there are specific provisions which are really bad for you, they're not valid. And we need the same when you have, for example, like software or code. Because, I mean, if you opt into something, or if you use a software, and there are really like lines of code which are like really awful. For example, for every transaction, let's say I use a blockchain, and for the next 5 years, I do a lot of transactions. Everything seems to be good, but in 5 years, it turns out that for every transaction, there was built in a function where in 3 years, wherever they are, they then deduct from all the wallets 10% of every transaction to another transaction. Mm-hmm. I mean, would you like to have such a thing? I don't think so. So I think, yes, this will be a challenge in the future. I like the basically the idea, because it helps people to understand what code is, but it just shocks lawyers, because it is not law from a legal perspective.
And in your opinion, what about security token standards? Because this is one attempt, to bring things into something single standard. Do you think that one standard can actually prevail in the future? And if yes, which one will it be?
Based on our experience, I mean, what we saw already now is that it's really a challenge, because there is no such thing as a standard, as you already mentioned, ERC 1400, you name it, whatever. They have some ideas, they have some functions which are really necessary, and we have more a functional approach, because what do you need from a token when you tokenize a security is basically the three functions as everywhere. Like you need the legitimization function, the liberation function, and the transportation function. And so I think we need more a functional approach in that respect as well. And you have to analyze your local legal framework, because there might be mandatory laws again, where you have to implement, for example, a specific function which you don't need in your country. So yes, there might be a minimum standard which will be maybe the leading one globally, but with a local additional rule set for jurisdictions, as long as we don't have a harmonized securities laws approach globally, which I don't think will ever happen. So we do have this in the European Union with the financial market framework, kind of, but the civil law is again, the civil law is in every jurisdiction quite different, or it's quite similar, but there are some differences as well. So and for example, it's very complicated. For example, how do you implement a burn function? I mean, you need a burn function if a token holder loses his private key and is not able to access anymore his tokens, or like to sign transactions. So what happens is that actually an entity loses a shareholder if it's a tokenized share. But I mean, that could not happen. I mean, think about that. In 5 years, nobody is the shareholder of an entity because everybody lost his private keys.
That's useful for the company.
Yeah, so you have to have a burn function, or you have to have a function where maybe after a court proceeding, you declare these shares invalid and issue new ones. But okay, what do you do with the token? Okay, burn it. But who is able to burn it? Is it like the party who did the public offering? Is it the entity, like the company you have the shares of? Is it the court? Is it the government? Is it the Financial Market Authority? The problem is when you do it within court or Financial Market Authority, you have a centralized, I mean, you have a single point of failure again. I mean, then in a big country, for example, you have one governmental institution holding all of the keys to the burn functions of all of the companies. I mean, that's horrible. That's very hard to secure properly, because you have there the single point of failure again. On the other hand, it's hard for the companies, or and I think that's the best solution as far as I thought about that the companies hold their burn function keys, because then it's decentralized again. Every company has their own burn functions, but that's just one, like, when you talk about security token standards, that's one function. It's a crucial function, but that's one function, and it's very hard to implement. And there, for example, you see again that this tech is really amazing and provides solutions which are incredible on the one hand. But I mean, on the other hand, you have to think about if to do it properly from the beginning, because afterwards, if you published your contract, I mean, it's done. It's you cannot like change it easily. So it's really a very challenging, from tech perspective, a very challenging task to provide a very good security token. To provide a security token and to provide standards. Like if you want to have a standard for the most use cases, that's even more challenging.
Going back again to the law and code dilemma. So the tech really is amazing, but still a lot of lawyers and a lot of people from traditional financial backgrounds still find themselves very unsure about the blockchain tech. They're not really familiar with the concept. And on the other hand, a lot of coders, a lot of blockchain people who previously stemmed from the ICO environment, they find securities laws pretty intimidating. And how do you think, is it possible to bring these two worlds together? What maybe educational steps are needed?
This will happen anyway, because it's just, as we see it, it's just such a more smooth, as you already said, smooth and cost-effective way of raising capital. And yes, it is in an area where you have really heavy regulation, and it will happen because you will see more and more fundraiser like this. So you will see more and more security token offerings, even if you have a lot of people saying, yeah, but what's the added value there? You can do an IPO, yes, but you don't do an IPO in every case. That's really inefficient. I mean, that's very costly. So what you will see is you will have like the companies approaching the lawyers and saying, you know what, we want to raise capital, but don't do it the standard way because you use this and that tech. We want to do a security token offering. So they have to get used to it. That's a part of the lawyers. And the other thing, I mean, that's just reality. If you tokenize shares, you are, I mean, that's heavily regulated. And yes, I mean, coming from the ICO world, that might be intimidating. I totally understand that, but in the end, that's manageable. I mean, if you have a good advisor, they will provide solution, and this will get better and better because I mean, it's just like that's like every single step will lead to more experience and more knowledge on both ends. So you will have like the industry will understand. Yes, now we are in heavily regulated area. We need this and that. But as I said, I mean, if you did the fifth security token offering, I mean, that's not incredibly challenging. Sure, it is challenging, but you can do it. You can manage it. You can write that prospectus, and then with experience, it will get easier and easier. And I think this will solve anyways. This will like be. I don't think that this will take forever. I think it will be faster than a lot of people expected from now on.
I have one final question for today, perhaps. In your opinion, what are the main trends and players in the space to look at?
I mean, the main trends and players, being a lawyer, I think, let me answer, or let me put it this way. I think what we need now is, and I really hope that we have government and other institutions thinking about that in the right way. I think now is the time. We saw that tech is working, that like Bitcoin did its way for 10 years now. And we saw a lot of possibilities. We saw a lot of use cases. I mean, Bitcoin for me is always proof of concept. It works. Then what we need now is we need now regulation really fostering and enabling the innovation behind it. And I really hope that we see jurisdictions, first of all, understanding the tech, and then start to regulate where needed and not over-regulate things. And I really hope that we see a trend of very good regulation, very balanced regulation, where you have on the one side legal certainty for the entrepreneurs, and on the other side you have consumer protection, investor protection, we have KYC, AML, and I hope we will see balanced regulation. And that's a trend I would like to see. I don't know. I mean, I see it from like what we see now is that it's that there are more and more jurisdictions trying to analyze it, and hopefully we'll see that.
Thank you very much, Thomas, for finding time and for being with us today.
Thank you for having me. It was a lot of fun.
This was Value Tokenized. Thank you for watching. Subscribe to our YouTube channel and to our Twitter for shorter versions of the video, and we'll see you next time.